I'm having some minor technical difficulties, which I think I can cure very quickly. So you guys can see the PowerPoint presentation.
Yes.
Yes. Okay. All right. So what I'm going to talk to you guys about is what I do in my practice. I'm in private practice, so obviously I'm always looking for cases that I can get paid on and that I can do the most good for the most people. I have kind of in the last couple of years shied away from individual landlord-tenant cases, mainly because I found that, especially up in Leon County, it was very difficult for me to get paid in those cases. I even had one judge one day tell me in the parking lot that don't come into that court thinking I was going to get paid on a landlord-tenant case. But I found that I can litigate landlord-tenant matters in circuit court as class action, and really be very effective there, and meet my need as a private attorney to make money. So I'm going to talk to you about some of the things that I'm looking for, and issues that I'm seeing in my litigation. The main thing I'm looking at most of the time has to do with fees. There are a lot of ways that landlords try to increase their profits by creating fees in lease agreements. They have liquidated damages provisions. They have lease termination notice fees. A lot of leases these days are providing for forfeiture of the tenant security deposit. And I'm sure you guys have all seen the claims that for damages that come out afterwards. Some of those can be fairly excessive. And these all, especially for our working class clients, all of these additional fees can really create a huge burden for them. The thing to remember is that the landlord's remedies are set by statute. The landlords can't put these provisions in. The statute really describes a landlord's remedies for a tenant's breach of the lease, a tenant's early termination, what they're allowed to recover for damages and for things like that.
No.
Can you guys hear me? Am I good? Yeah. Okay. So the landlord's remedies are fixed, and this is a Florida statute, and it's a really great statute to be aware of, because when they start charging unlawful fees, they include those provisions. If your client pays them, you've got a cause of action to recover those damages. So you don't just have to do it. And the landlords will always say, well, they agreed to it in the contract. And that's what I hear all the time. And the answer is no. That contract provision is void as a matter of law. It's unenforceable, and my client has the right to go get that money back. And here's where the landlord's remedies are. And it specifically says, especially when we're talking about issues where there's an eviction, or where somebody can't pay the rent or just chooses not to. A lot of times tenants don't really know how to go through the process of giving the landlord the notice and opportunity to cure necessary for invoking the statutory protection, where they can either terminate the lease or withhold rent. They're not aware of that in so many cases. But even when they don't follow the rules, the landlord's remedies are limited, right? They can basically get an eviction and retake possession, and when they retake possession, that terminates the tenant's liability. So they don't get to take it and then keep charging rent. They can, if they can retake possession in some instances for the account of the tenant. They have to actually say that that's what they're doing. But then they have a duty to mitigate the damages. They have to try to re-rent the property. And I've won cases. When I was doing some of the individual cases, I would often win because those cases where they were suing the tenant for monetary damages because they were not really trying to re-rent. I had one case where when after the tenant moved out, the landlord decided to remodel the home. It was an individual house that was being rented, and the landlord put a for sale sign in front of it, and then wanted the rent for the duration of the lease period. And the judge said no, because again, you've got to be trying to re-rent it. Putting it up for sale is not mitigating your rental damages. And then I'm going to talk more about this thing in Chapter 4 about the liquidated damages provision. The takeaway points on that is really that any liquidated damages has to be optional to the tenant, and it cannot exceed 2 months' rent. And I'm seeing a lot of violations of this in leases. So you want to keep your eye on that. And it comes in some kind of sneaky ways. You want to watch out for these hidden provisions that are buried in the lease agreements. So and you see these like little paragraphs. If you do not fulfill the original lease term, you're forfeiting your security deposit. Well, the law doesn't say you forfeit your security deposit as liquidated damages. All right, and if you notice this, right, this lease provision actually, you get liquidated damages even if there are no other damages, right? And you shall additionally pay for rent until the unit is re-rented. So they're actually they're using these types of provisions to collect both actual damages and liquidated damages, which is basic contract law. You don't get to do both, right? Liquidated damages are only allowed in instances where actual damages can be difficult to calculate. So you can see these guys, these landlords are double dipping on this stuff. And these provisions actually, I think, give a landlord an incentive to, in some cases, to promote a default by the tenant. And I see Rachel raised her hand.
Yeah, I'm getting some feedback that the screen is small, like this PowerPoint's small, and it looks a little small on my computer as well. So is there?
Yeah, I can, let me see. I think I know what's going on. This. Oh, interesting. Okay.
Sorry to interrupt. I just want to make sure we're all following.
I'm glad you did, because I think
it might have something to do with settings. I don't.
No, I think I know what's going on. Is that better?
Let's see.
Yeah, that's much better.
All right. Yeah, you guys, I think we're getting the presenter view, and all right. Turn off my phone. Yeah. So now
is that better, everyone? Are we good? Okay.
Okay.
Hold on. Aim's saying no. Hold on. Okay. Does anyone have any ideas how to make the PowerPoint fit the screen?
On my screen, it's fully fitting the screen.
Okay.
Anyone else having trouble?
I'm having trouble, and it looks like Ain is as well. Hold on. Huh. I mean, it's probably, she just sent me a picture of her screen. I think her screen looks better than mine. I think it's maybe our own computer settings. Oh, that looks good. Whatever I just did looks good. So Melva said you can adjust your view if you do not have, okay. All right, I can see now, so sorry to interrupt. I'm gonna stop talking. Thank you.
Okay, all right. Yeah, please let me know if there's any problems with this, or if you can't hear me or something. I'm happy to adjust if needed. So anyway, these provisions, like I said, they bury them in the fine print of the leases, and then they come back at our clients with this kind of stuff. Hold on, let me see. You see. Here's another version of what we see. Early termination. Again, you have to pay a lease termination fee equal to 2 months' rent, and then you forfeit your security deposit. It becomes the unconditional property as liquidated damages. Well, as we saw before, the statute says that your liquidated damages are limited to 2 months' rent, and it has to be at the election of the tenant. In other words, when you create the lease, I'll take you back and show you the statute here in section 4. It has to be a provisional thing where the tenant agrees or does not agree to liquidated damages. And again, only 2 months rent. So when you add in a security deposit, you've created a violation of the statute. And as we know, that's not allowed. The remedies are set by law. Landlords can't alter that in their contracts. There's actually a case law that says that. And this is all part of what I call the gotcha component. Gotcha capitalism if you haven't read that book, is a great book. And what they're trying to do, they're creating these little catch areas for the tenants, and all just pure profit for the landlords. So here's another provision that is this okay? Is what I'm going to ask, and I don't know if we have the ability to discuss this, but you can see this is one, and this is actually a case I'm actually in settlement on right now, and this one, again, it's not an optional provision; it's a mandatory one, and it's liquidated damages in the amount of 3 months rental payments. So it's 3 months of liquidated damages. And the landlord retains all other remedies for non-compliance of the lease. And I'll show you what they actually charged my client in this case. They took the client's $550 security deposit. And by the way, this was a case where the client moved out because the landlord was failing to maintain the property. It wasn't that she didn't have any money, they just wouldn't fix things for her, and she finally had enough. She actually told them in advance she was moving out. She didn't technically follow the statute the way she should have, but they came back and slammed her with this thing. Early termination fee of $2,680. Like I said, the forfeiture of the deposit. So they're actually hitting her for $3,900 bucks. Oops, sorry, I didn't mean to go that far. And then they sell her this. Rent will be accrued and charged to the balance. So they're going to keep charging her rent. They're taking her deposit and they're charging liquidated damages. Again, not allowed. And what I found out was when I did discovery in this case, the landlord in the last, I think it was the last 2 years, had collected about $93,000 in these types of fees. So when I see this, pow, I'm suing these guys. Right? These are really good lawsuits. The other thing that I pay a lot of attention to are after my clients move out, what are they getting for damage fees? This is a case that turned into a class action that I did. And these are the fees that were placed on my client's account. They charged her $495 for cleaning a kitchen. If you can imagine this, almost $500 for cleaning the kitchen. If you could get $500 for cleaning a kitchen, I would give up the practice of law today and go into the kitchen cleaning business. $60 for drip paint. If you go to Home Depot, you can get a whole set of drip pans for I think about $8 the last time I looked. They're cheap. Right? But the real one that really was very offensive and I think is really what drove the client in to see us was she got this charge for carpet replacement of $5,600 for replacing 270 square feet of carpet, which is ridiculously high. What we actually found out in this case was going on was that they were doing a remodel on the entire apartment complex, and they never actually replaced the carpet. They put in a tile floor when she moved out. In all the apartments, anytime a tenant moved out, they put in a tile floor, and then they billed the tenant for they said, well, it was carpet damage. My client came in with a great video. Sometimes people really do the footwork for us, and it was an old carpet, but there wasn't any damage that she caused to it. The apartment actually looked immaculate when she moved out. What they did is they put in a tile floor. So they took out the carpet, put in a tile floor as part of a remodel and upgrade to all the apartments. It was going on in every unit. And they were doing this to every tenant that moved out. And they didn't even charge them the price of the tile floor. They tripled the amount. So my client got a bill for about $7,500 originally from the apartment complex, and then they sent her off to a collection agency that added another 50%. So they added 50% again. So she gets a bill for $11,325.63. And so all of a sudden I have all these people coming in my office that have got these ridiculously high claims for damage from this apartment complex. This was up in Tallahassee. And so we were able to do that as a class action. And the recovery was both in actual damages and debt relief for the clients was huge. Was actually a fairly big case. And there was actually a very good Cypre award that came along with that too. And it was a good case. Like I said, the facts in these cases sometimes are really shocking. So, but again, when I see this stuff, bam, these are great class action lawsuits where you can really do some real good for people. Because again, if you think about an $11,000 bill for any of us is a big hit. The other thing that I'm paying a lot of attention to are the notices that are placed at the bottom of the security deposit notices. Florida law is very specific about there has to be at the bottom of the notice of claim is the tenant security deposit. If the landlord is going to make a claim, they have to give this notice here in the middle about their notice of intention to impose a claim and the right of the tenant to dispute that and the process. And this all has to be sent by certified mail. A lot of the landlords aren't doing that either. And what's great about this type of stuff is when the landlord doesn't give the notice, all right, they lose the right to impose a claim on the security deposit. And they may not seek to recover against the deposit until they have returned the security deposit. And this comes up in my litigation all the time where if I file a class action, they'll try to disqualify my class representative saying, well, we've got a claim against the class rep because, they actually owe us money for damages. And I'm able to successfully defend that because they don't get to do that until after they return the deposit. And so I've prevailed on that every time that they've ever raised that issue. So it's a very good statute. You can help a lot of tenants here. You get them back their security deposit. And the truth is the landlords are not going to go out and file a bunch of individual lawsuits to recover this money from the clients. It's not economically feasible. We know in class administration of these cases that about 30% of the tenants, they can't even find them to get to deliver the deposits back to them. So those fees go into a Cypre fund that generally goes to a legal services organization. These are actually some of my favorite cases to do it. And generally with the settlements is we get them to waive any damages. Because the truth is their amount of recovery of damages from tenants that have moved out, it's generally pretty minimal anyways. It doesn't really have a lot of value to the landlord, but it has great value to our clients because it can repair a ding on their credit and let them move on, and it makes it easier for them to rent apartments in the future. Here's what, like I said, this is one of the cases I recently did that brings in a couple issues. You see that the notice of the deposit doesn't have that language about the tenant's right to dispute it. The other thing that happened in this case was lease termination fee. They charged her $965. She actually gave them 45 days instead of 60 days notice of that she was moving out. And so they assessed her this $965 fee. But the statute actually requires that the landlord has to provide written notice to the tenants before they can impose that fee. And in this case, the landlord had not given that notice. These guys were really, this was a great case because this company, Apartment Management Consultants, I had just completed a landlord, a class action against them for not including these notices. And then they went and did it again. And I'm just like, how difficult is that to solve? So what's happening in this market is these companies are managing dozens and dozens of properties. There are a lot of these companies like Apartment Management Consultant. They were located in Utah, so they're out of state. They're not paying attention to Florida law, and they don't train their employees very well. So you often see them going back and doing the same things they did before. Again, this was the second case I had against them where they didn't give the right notice, and then this case we had the lease termination cost issue as well, and we were able to recover both of those and get a class certified, and the case eventually settled, and we settled on a class-wide basis. And these notice provisions, these lease termination notice provisions, they will bury them in the lease so that nobody other than a lawyer might notice that they're even there, and then spring them on the tenants, which is why the statute has that requirement that the landlord provide notice to the tenant of the termination notice requirement, along with it can't just say you have to give a 60 days notice. It has to also say what will happen if you don't. What are the fees and stuff that you can incur? This one, reading through it, I have no idea what the fee actually is, because it says the resident will be charged for the balance of the notice period and an amount based on the daily prorated rental amount. I have no idea what that actually means. And this, by the way, this little provision is buried in this. So you see it's actually provision G buried in all this other language. So how likely is it that somebody would actually notice that in there and know a year later, or sometimes several years later, that they have to give the written notice prior that they're not going to renew the lease. I also think, and I haven't really litigated against, I also think these things where the landlords create all these conditions for getting back your security deposit, I think there's some real problems with these, and I expect that at some point that'll be the subject of future litigation, because I think the law is such that you can't condition return of the security deposit on anything other than your actual damages. I don't think you can do this. The other part that I bring, I don't just bring claims under the Florida Residential Landlord Tenant Act, but I also bring claims under the Florida Consumer Collection Practices Act. If you're not familiar with that statute, get familiar with it, because it is how the Florida legislature ever passed this, because they're not a really consumer-friendly group. It just amazes me. This is one of the best consumer collection practice acts, I think, in the United States, and I hope that the legislature never realizes it's there, because I use it a lot, and I use it carefully. I don't bring a lot of technical violations. I try to bring things where people are really being harmed, but it has this provision that you can't assert the existence of a legal right which doesn't exist. And the statute is very clear about what the landlord's remedies are. So when the landlord creates these expansive remedies that go beyond the statute, I feel that it violates this. And what this gets us that's really nice is you get a right to both actual and statutory damages, and you can do that in both an individual claim and in a class action. It's very similar to the Federal Fair Debt Collection Practice Act, except that this act says no person shall, right? Whereas the Fair Debt Collection Practice Act only applies to debt collectors. And I've never really explored the issue of whether or not the federal statute, the FCCPA, applies to property management companies. And I'm not aware of any case law on that, but this statute clearly applies to property managers and landlords. So you can actually be the creditor and be liable under the Florida Act, which is much better than what we get with the federal act. And these are really safe claims for us to bring for our clients because it's a one-way attorney fee provision, meaning that the plaintiff or the consumer can recover their costs and attorney's fees, but the other side can't unless you've really raised a frivolous claim. So it's a very safe statute to sue under. And the other thing this thing will do is you can get punitive damages under it. So this is a great statute that can really help a lot of our tenants. So like I said, I see these things, and this is what goes through my head. Bazinga! I'm going to sue these guys, and that's really what I've been doing. Kind of an overview of the stuff that I've been doing with the landlord tenants, and I'd like to at this point just open it up for questions. And one thing I didn't cover that I probably should have included in the presentation. I'm going to say this right before I end. Your client's 3-day notices that they receive are, and I do have a case where I litigated this. Defective 3-day notices can be FCCPA violations, where they start trying to collect money that's not owed or is not lawfully allowed. You can actually bring an FCCPA violation on those violations, and I do them as a class action because landlords use the same forms over and over again, right? The leases are the same, the 3-day notices are the same, the deposit collection, claim forms are all the same. So these are really great cases to bring as class actions. They're not, to me, economically feasible to do as individual cases, but as a class, they're beautiful. They're just great cases to bring. So you do want to look at your 3-day notices because there can be violations in there. And with that, let's open it up to questions and see what people have to say.
All right, Melba had a question, so I'm gonna see if I can unmute her. Hopefully I can. So she can ask her question.
Okay.
Okay, I can't. Hold on, let's see.
Okay, yeah, Melba asked a question I see in the chat. Is the failure of the client to timely object to the notice of intent fatal to any subsequent action by the tenant? No, it's not fatal do it. If the notice is defective, then you've got a claim based, because I mean, that's the purpose of the notice, is to let the client know of the ability to object. So no, you don't lose that. Otherwise, they'd be able to defeat our class certification, because they'd say, well, the ones that objected versus the ones that don't. But that's not a problem. So yeah, don't worry about that. If the notice is bad, then they don't get to keep that security deposit, and they can't even file a claim until they return the money. So.
Okay. Can you hear me? You can hear me, right?
Yes, I can hear you.
Okay, so thank you very much. That was really great. I was wondering if you wouldn't mind sharing. I mean, obviously you might have to go back and look. I doubt you know this off the top of your head, but some either case numbers or complaints of some of these issues that or these cases that you mentioned, just so that we have, I know it's, kind of technical. If we had kind of, I think the complaint, we might be able to maybe issue spot it in the future, and then maybe utilize your complaints, if you wouldn't mind sharing. I know that would help me.
Right. Yeah, I can forward you a list of some of these cases that we've done, so that you can reference those, and I can send you. Believe it or not, the complaints are all kind of fairly similar. So if I give you one, you've kind of seen most of them. So I can do that.
Yeah, I think that would be very helpful. Sure. I would appreciate that.
Right. No, it helps to not have to reinvent the wheel.
Yeah. Well, definitely, especially when we're going to be dealing with like so many tenants coming in with eviction. Right. So, I mean, obviously that would be really helpful. So
sure.
So thank you.
Right. Yeah. Any other questions?
Any other questions, guys? Well, I want to thank you on behalf of Legal Aid Society and our team for sharing of your talent and all this information. As we are gearing up for the end of the eviction moratorium, we're just trying to find other creative ways to try to help tenants, as best we can, so that, we don't have a bunch of tenants who are being displaced and with, lots of money judgments. So if there are any ways that we can try to challenge using consumer law, that's what we're going to try to start looking to do. But thank you so much, and we appreciate you.
Sure. I'll say one last thing, because you guys are going to be doing a lot of the eviction, challenging the actual evictions, which I don't spend a lot of time really working in, but there's really some interesting things happening right now with Florida's requirement, the pay-to-play rule in evictions, where if the client doesn't post the rent into the court registry, they basically lose the case automatically, which is a huge problem in defending evictions right now. There's actually there's a HUD guidance document that says that HUD considers that provision in Florida law to be unconstitutional. And it's really an issue that somebody needs to take up and challenge at some point. Because
is that a recent HUD memo? Because I thought they deemed our process, similar to the due process standard, and when it comes to like effectuating in public housing eviction, CFR.
I haven't seen anything recently come down that challenged that guidance document that was issued a few years ago. But I think there's really strong arguments that requiring pay to play violates constitutional standards. We don't require it in any other area of law, and I'm not sure why it's, other than the landlords have a lot of political influence, why it's required in a landlord-tenant action. I know that sometimes the private or volunteer attorneys can get surprised because they want to go in and argue the case, and the client hasn't put the money in the registry, and all of a sudden they've lost the case before they ever got out the gate.
Yeah, I mean, that's something that we're challenged with here too, is that, you know, the client has to we either have to have a good faith, something argument to put in a motion to determine rent, or have the client have the ability to put the money in the registry. And then also there's the discussion with the client as to whether if we put, you know, 2 months of rent in the registry, you may lose that money. And if, you know,
Right.
you know, you have to kind of make a decision whether you put $2,000 in the registry or use that money to move somewhere else, you know, if depending on how the case goes.
Right, right. Yeah, I agree. I think it puts the client in a tough position. But I think constitutionally, I think there's real problems with that rule, and I haven't seen anything come down from the appellate courts on it. So maybe it's an issue that's ripe for some litigation. Melba asked another question that says, why is it cost prohibitive to bring the Florida Deceptive Trade cases? No, I think Florida Deceptive Trade Practices Act cases can be done on an individual basis effectively. Florida landlord tenant cases, when we're talking about these unlawful fees, I have not found that I can do those because a lot of these cases are the rent's $500, and I wind up in a dogfight with a landlord who wants to litigate this thing like it's a death penalty case over $500, and then going to a county court judge and ask them for a reasonable attorney fee has not worked out well for me. I have one case that I actually did, and this was an eviction case. It kind of soured me on litigating these cases on an individual basis, where we won on an eviction case, which goes on this rocket docket. It wasn't a non-payment. It was another issue that was the basis for the eviction. And we won it, and the judge lowered my hourly rate to a very low amount and took away 80% of the fees. And so we did this thing. We took it all the way through trial, and the judge awarded us, me and my co-counsel, we got $2,000 in fees, and we spent hours and hours and hired investigators and all kinds of stuff to win that case. And I would love to be able to economically do those cases. That case felt really good intrinsically to do, but economically it was a disaster for me. So, yeah.
Okay, well, thank you so much, and we appreciate all of your information and guidance this morning.
Thank you guys for having me. And I'm here to help you guys with any of this stuff. If you see it going on, I'm very happy to work with any of you. And I think these are important cases. I really feel very passionate about this type of work. So don't hesitate to call me and look me up. And I'm happy to work with anyone.
All right. Thank you so much. All right.
Thank you so much.
Day.
All right. Rachel, Takesha, and everybody who attended, thank you guys.
Thank you.
Thank you. All righty. Bye-bye.
Bye.